And Judge, my reading of the motion in limine in regards to the implied consent statute, I don't see anything in here challenging anything that would require an officer's test. I'm seeing this is just legal argument.
I really didn't see anything, but I'm just curious about the speedy trial demand.
Yes. Yes,
When
Your
was
Honor.
that filed?
It was filed on February 12th, 2020.
And then what the probably I didn't find it. Okay.
Well, Judge, that was filed. So the case started in municipal court and Mr. Head filed a demand for a jury trial and a demand for a constitutional speedy trial in municipal court on February 11th of 2020. The case was then bound over to the state court of Fulton County on February 12th of 2020. We received it in our office on February 21st of 2020.
All right. Okay. Mr. Gaither, I think I just saw him come in. Did he walk out again? Okay. All right. The only thing is, Mr. Head, since the only camera we have right now is at that podium where you'll be making your legal arguments, right? I'm
Okay.
going to go ahead and begin the hearing because we don't have any witnesses.
Well, my client's going to be a witness.
Well, he'll be sitting right here and that will also be on video.
Okay. And so will I be standing over here?
Yeah.
Okay. Okay. Sounds good. I can hear myself very well.
That's
I'll go into the
as
system.
long as Ms. Green can hear you, that's also perfectly fine. Thank you.
All right.
Okay, let's begin. We have case 20 CR 005-729F, State versus Michael Insani, accused of driving under the influence of alcohol, less safe, and failure to maintain lane or improper lane change from July 29th, 2019, allegedly in Fulton County. Mr. Thani, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney and are represented by Mr. William Head. With regard to this particular case, the prosecution is going to be the Assistant Solicitor General, Ms. Jordan Reiser, correct? Okay. All right, this matter is being reported. The court reporter is appearing virtually, but she has been advised as to the location of the witnesses and the ability to hear the witnesses or the attorneys who are arguing. So we have a motion, an immunity motion that was filed by the defense, as I indicated.
It's a speedy trial motion.
I'm sorry. Let's just be, I was just looking at the case. A motion to suppress, which was filed on April 17th. Are we still proceeding with that?
Yes, Your Honor, if we hear the speedy trial issue and you grant that, we won't even have to go into the blood. And then I'm planning to address the speedy, I'm ready to address the speedy trial issue first because it does require some evidence. I need stickers so I can put stickers on my exhibits. Do we have any stickers here?
We don't have stickers here. You probably need to use Post-its and or you can just mark it on the exhibit and the court reporter, when she has access to it. This is the challenges of virtual proceedings. So
Okay.
how many documents do you have?
Good. I got plenty of them, but would it be okay if I go up to one of the state courts and see if they have some, because they usually have them right in the drawers in state court.
Will a Post-it do for now?
I just worry about them getting mixed up, and if they're not attached, they're usually stuck to the document.
That's true.
And if something gets mixed up, if it goes up on appeal, it's going to be a mess.
All right. You will take a 10-minute recess and Mr. Head is going to go look for document exhibit stickers.
You can stay here, go out and use the restroom. It won't take me long. I just have to go back across
All
the
right.
bridge.
Yeah.
Judge, not to interrupt, I've got the calendar, I've got all the notes. That was our only position on the 9 a.m. calendar. May I be excused? I'll stick around and listen. I just wanted to thank you, Judge.
Thank you.
Shoot him an email. Anyway. Oh, sure. Oh, veterans? They're all veterans. No, I think two of them are addition therapy warrants. One is a probation warrant, and the other two, they have warrants, but it's not showing. I just put the warrant, but the ones that are active. Okay, show up in court when you know what to do. Show up right soon, girl. Would you like me to let them know that looks like there are 5 of them in the calendar? Yeah, tell them to start filling yourself in. If we tell them that, they will follow along.
What did I do that you about? Huh? Yes, I did that you. You was showing, I can't hear nothing you saying. Wanna be. Well, we in recess, so you're good. Oh. The one I just showed you. It feels showing open.
That's the problem. I need to figure out where the null process went on those 2 cases, because I wasn't here Friday, so someone
It's
should
showing,
have.
it's showing on the first one, but not the.
I emailed them to state court, state.orca.
Yeah, I'm trying to figure out who has it. Because they should have put it in the file and uploaded it. And at least made me aware and put a note in the comment section. Already know across and some. No, conversation to be had when I get upset. That's all. I'm serious.
And who put saying that no, put what it is, they just put it final disposition.
And it shouldn't be, it should be.
It should
if you-
say what it is.
Exactly. So,
stickers, so can you do me a favor and bring? Any exhibits. So, I said, I got a feeling I'm not going to be able to find any. And some binder clips. But if I have to take the exhibit in, I can make sure that they don't get stuck with something else and turn it over to the court reporter. If you look, no, the short. one. Little short. one. Different. It's little small ones. Different colors.
Ms. Greenhouse, we're still waiting for Mr. Head to reappear. We need exhibit stickers.
Yes, thank you.
About it. That's, things that about it, tax management was too. He didn't want to. No, I got it. Okay. Thank you. I had Mr. Glenville call Ms. Bailey, he's over.
Okay.
Oh, I didn't have my phone, so I couldn't call anybody.
Alrighty.
Got my exercise for today.
Mr. Head, I'm so glad for you. Okay. On the table also, I've given both the state and the defense, the Superior Court of Fulton County order by Judge Glanville that was filed on December 27, 2022, regarding an order granting relief from statutory speedy trial requirements pursuant to OCGA 38-3-62B. So a copy was furnished to both the state and defense. And whenever you're ready, Mr. Head, you will begin your argument. I'll call you first witness.
Okay, as far as this exhibit, I'll kind of go ahead and just mark that as defendants 1.
That will be defendants 1, perfectly fine.
And I need to stand over here to do my.
Yes.
Okay, let me get over there then. All right, Judge, if I could, I'll give you an overview. And the one thing I didn't have, and this may be too loud, I don't know, but
No, you're perfectly fine.
okay. I didn't have the date that the solicitors received it from state municipal court of Sandy Springs. And I heard that that was on February 21st, I believe, of 2020.
The accusation was filed with the State Court of Fulton County on February 11th, 2020. I don't know if that answers your question.
Okay, well, it was still in Sandy Springs on February 11th. The speedy trial demand was filed by me on February 11th in Sandy Springs. And then it was bound over to state court and they received it February 21st. I believe that's the date.
November 20th. November 20th, 2020 was when the accusation was filed.
Right, that's that's a different date though. They received the package from Sandy Springs Municipal Court, which was dated February 12th. They received it February 21st. Am I correct?
Yes, and let me just confirm, it's really quick.
All right, I'm just going to go over a timeline over here just to get everyone on the same page, okay? And y'all can correct me. The alleged date of the incident is July 29, 2019. There was the bind over date from Municipal Court of Sandy Springs was on February 12, 2020.
That's correct.
The accusation was filed with the State Court of Fulton County on November 20th, 2020. And then discovery was filed with the state court. The certificate of discovery was submitted on June 16, 2021. And then additional discovery was filed on August 25th, 2021. I'm going to pause right there. Are there any dates that I need to fill in?
Well, the February 21st is when they received it from Sandy Springs. They didn't accuse it until the later date that you gave.
Okay. Received by Solicitor General's Office of Fulton County on what date?
February 21st of 2020.
Okay.
And yes, Judge, so there are a couple other dates that I want the court to have on their timeline.
Okay.
So when it was bound over on February, we received it in our office, February 21st of 2020. Obviously, March 14th of 2020, the Georgia Supreme Court tolling order went into effect. And that was a tolling order suspending jury trials from March 14th of 2020 to, I believe, June 2021. So jury trials were delayed by the Supreme Court of Georgia and their orders for a total of 1 year, 3 months, 16 days. So that's short of just 16 months that jury trials were suspended and or tolled. Okay, and then the court was correct. State Court of Fulton County formally accused this case on November 20th, 2020. Defendant had a plan arraignment on plan arraignment on June 22nd, 2021.
But it wasn't held due to COVID.
Correct. Yes, that's correct. And so the court docket, Judge, if you look at the docket, it says court reset. And I believe, as Mr. Head indicated, it wasn't held because of COVID.
Correct.
And then defendant had another plan arraignment date on August 25th of 2021, where the defendant waived arraignment and requested a jury trial. And Judge, this case was originally assigned to Judge Richardson, but due to the creation of the Orca division to handle the backlog of COVID cases in Fulton County, this case, based on the date range, Orca is from 2015 to I believe the end of 2021. Orca, based on that date range, the state court judges had an ability to transfer it to the Orca division to help with the backlog. So this case was transferred to the Orca division on March 2nd of 2022.
Okay.
And then obviously we had a status date in the Orca division on April 6th of 2023. And we hear on motions today for June 2nd, 2023.
All right. Any other dates we should include, Mr.
All right, and I appreciate that because that filled in a couple of things I didn't know. And I actually had accounted for 1 year and 2 months, but it's actually 1 year, 3 months and 19 days,
16 days.
16 days. Okay.
Mhm. So I think it's just short of 16 months. And then, of course, the order from
Randall?
Chief Judge Glanville, which appears that let me see. And there was a previous court order that suspended the speedy trial deadlines from May 2nd, 2022 until January of 2023.
All right, and that's exhibit 1.
Yeah.
Now the difference between his order is that applies to statutory speedy trials. It does not apply to constitutional. speedy
Understood. I just wanted to let that out there.
Right,
also.
right. And so I'm allowing for the COVID, and I had made my calculations allowing for let me see here, 420 days, but it turns out it's only 404 days. So that being taken into account, this case has been going for 1,150 days. And I believe that that's the number of days it's been going. So you deduct 404 days, and even if you use the date of the time we file a speedy trial, it's still well over 2 years. It's 2 years and 14 days.
All right, Mr. Head, I'm still waiting for you to go through the elements
Okay.
to see how it was not satisfied.
I just want you to know the dates.
Mhm.
Okay. All right. Since I'm going to show this to the prosecutor, but I'm going to mark it as mark this as D2. And it's I had the Sandy Springs. I went and had them do a certified record so that would be part of this record.
All right.
All right. Now, when my client testifies, where are we going to have him?
We're going to have him seated at this chair right here,
All right. But
and then he'll be facing the camera.
all right, I just want to make sure. But, and Judge, you had a good point. Let's go over what the requirements are for this. And we had a brand new printer put in for the first time in 20 years yesterday, and it didn't work for my computer. So I forwarded all of my cases over to Ms. Reiser. I didn't have your email, so I said, if you would forward them to the judge, you'll have them on your email.
Okay,
So it's been a heck of a morning.
that's quite right. If you need a moment to pause, or
I could use some water if there's any around, so. But I sure didn't stop for any water on this trip.
just give me a moment. This is a unopened bottle.
That's fine, thank you. I'd even take it open one at this point.
Well.
I figure if COVID hadn't got me by now, it's not gonna get me.
So glad you're still with us.
Okay. And I'm going, this standard is completely different than the statutory standards. Then that's 2 terms of court at which both terms had jurors available. And so the COVID knew that that wasn't going to happen. In fact, I did the last trial. It was March 5th and 6th with Patsy Porter. And the last trial that was done, because the next Monday they did the stand down. So the 4 factors under the dogged and I call it the dogged factors was the delay excessively long? And the cases I sent you indicate that 12 months on a misdemeanor is the standard. And that those cases will have that principle covered. Was the defendant responsible or the state responsible? Well, we've never missed court. We've announced and we filed on time each time, both in Sandy Springs and here. Did the defendant timely assert it? I don't think there's any question about that, because the Lackey case, LAKYI, says that once it's filed in the underlying non-jury court, it applies to the state court. The 4th element is, did the defendant suffer any prejudice as a result of the delay? And that's where we are. So that's why I'm giving the court that preview. So I'm going to have him get up on the stand, because we'll have to ask and answer some questions. But if he's going to be over there, I don't even know how I can see him. So
Would you like to reposition yourself?
can this be repositioned?
I don't believe so, because it's wired. This courtroom was originally wired to handle virtual proceedings. So you would have to, you can speak from your desk if you like, and Mr. Sani will be seated there.
I could see him from there. Is that okay?
That'd be good.
Okay,
Are we calling Mr. Sani to the witness stand then?
we are.
Okay, Mr. Sani, please. Right, please raise your right hand. Solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
I do.
Thank you. Please be seated. If you could, would you be able to bring your chair forward? All right. And if you could just do a testing 1, 2, 3 in your mic.
Testing 1, 2, 3.
Ms. Greenhouse, can you hear him? Okay, thank you.
And can you hear me, Miss Greenhouse? Okay, good, good. All right, great. So I'm gonna have to move to his seat to see him. Got a big computer monitor in the way.
Are you comfortable,
Plenty
sir?
of empty courtrooms upstairs. All we had to do was go up and get a good courtroom. They're all empty. All right. How this is gonna work. Now, I gotta make sure that Ms. Greenhouse can see. Can you hear me still?
Yes, Mr. Head, I can hear you. I don't see you, but I can hear you.
Okay. I'll try to speak up, but when I turn this way, I can't see him. I have to get over here to see him. Can you hear me from here?
I can still hear you from there. Yes, as long as you just speak loudly, that seems to work.
Okay, if you have any problem, I'll repeat it or whatever, because I know this is very awkward for you too.
Thank you. Appreciate it.
All right. All right. Mr. Sani, I'm going to speak loudly here. Try to keep an eye on you since I can't see through that computer screen. So first of all, state your full name for the record.
Manmohan Sani.
Okay, and how old are you, sir?
I'm 42.
And can you tell the court whether or not you are an American citizen?
I am not. I'm a permanent resident.
Okay, and what nationality are you, Mr. Sani?
I'm Norwegian.
All right, and did your family originate in Norway or did they migrate to Norway?
They migrated to Norway from
Where
India.
was your family originally from?
From India.
And what year did your family migrate from India to Norway?
1988, 1989.
Okay, and what was the reason they left?
Because of the genocide against my people in India.
Can you be more specific for the court?
Because of the genocide against the Sikh religion in India.
Okay, and when your family left India, who was part of the family before you were born? Who left?
My father and my mother.
Okay, so there were no children then?
No, sir.
All right, and the family went to Norway, and is that where you were born?
Yes, sir.
And where are the family members? Are there any family members in your family still alive?
Yes, sir. They're in Norway, India, and England as well.
Other than the United States?
Yes, sir.
Okay, who among your family are in the United States?
Uncles, aunts, and some cousins, and my mother from time to time.
Your mother?
Mm-hmm.
Okay, and when she's in the United States, where does she live?
With me.
Okay, and so at what point in time did your family go from Norway to the United States?
The year?
Yes, sir.
All right, 91, sir.
Okay, and in 1991, who came to the United States from your family?
My father, my mother, and my brothers.
Okay, and are both your brothers still living?
One of them is
Okay, and where does he live?
Norway.
All right, and so you've been in the United States, and where did your family come to in the United States when you first arrived here?
To Hinesville, Georgia.
South Georgia?
Yes, sir.
Okay, and did you finish your education there?
Yes, sir.
And did you ever go to college after finishing your high school education?
Yes, sir. At Georgia Southern University.
Did you get your degree?
I got associates.
Okay, and so in the Hinesville area, did your family did you work down there or have a family business down there? What was going on down there?
Family business, sir.
Okay, and did you work in that business?
Yes, sir.
Did your mother work in that business?
Yes, sir.
Now, is your father still living?
No, sir.
When did he pass away?
In 1998.
Okay, was he part of the business before he passed away?
Yes, sir.
All right, and do you still own any businesses in South Georgia?
I do. Yes, sir.
Okay, and so you still have a business down there?
Mm-hmm.
All right, is that, always say yes, not, okay.
Yes, sir.
Okay. And so, as far as the business down there, do you or your mother or any family members have any part in it, or is it just a business you own?
Businesses I own.
Okay. So, how long have you been in the Metro Atlanta area?
Since 2019.
Okay, and so, do you remember the month?
I would say like February, March.
Okay, be able to speak up because I'm having a little difficulty.
February or March.
Okay. And so, do you presently have businesses here?
I do.
How many different locations?
12.
Okay. And are those businesses managed by you and overseen by you?
Yes, they are.
Okay. Now, when you received this citation in this case, in July of 2029, what was your, I'm sorry, July 29, 2019, what was the status of your driver's license?
It was valid.
Okay. And it's out. Mark is defendant's exhibit 3. Okay, I've handed you what's been marked as defendant's exhibit 3. Is that a true and accurate copy of the driver's license you had when you were arrested?
Yes, sir.
And that's on July 29th, 2019. Correct.
Yes.
Now, on that license at the top, and I don't have a copy in front of the judge, but I need you, let me see if I can hand one up so the judge.
That's fine.
Okay.
You can, I'll review it later.
Okay. At the top of the license, it says limited term driver's license. Is that correct?
Yes.
And when did that driver's license expire?
8/24/21.
Okay. And was that 8/24/21 date a significant date in terms of the driver's license?
It is because it expires same time my permanent resident card expires.
Okay. And so while this case was pending, and on that same date of August 24th, 2019, did your green card expire?
But you mean 2021?
2021, I'm sorry.
Yes, sir.
Marking this as defendant's exhibit 4. I'm going to bring it up for you.
Judge, I'm just, is this defendant's 3, is that moved to be tendered into evidence, or
Mr. Head?
what are we doing with these exhibits?
Oh,
Yes, I was going to do them all at once, but I'll do it individually.
would it be easier to do it individually, Ms. Reiser?
Yes, just to keep track, because there may be different objections based on what is,
So far, I've only got 2 documents marked as exhibit 1, exhibit 2, and now I have a third one marked as exhibit 3. So, Mr. Head, what would you like to do with exhibits 1 and 2?
I would like to admit them, and unless there's an objection by the state.
1, no objection, 2, no objection, 3, I don't really see the relevance in it. The defendant just testified that to the, I think the D3 is duplicative or cumulative. I don't think there's a relevant or a purpose for it to be admitted.
Mr. Head?
Well, I'm going to show, Your Honor, that by virtue of the delay in this case, he was without a license.
Exhibit
that's-
3 is admitted over objection.
Okay, thank you. And before, as I've already stated, is the next exhibit. Ask you if you can. All right, Mr. Sonny, I've given you defendant's exhibit 4. Could you tell the court what that is?
That's my permanent resident card, sir.
Is that also known as a green card?
Yes, sir.
All right. And does that reflect the same date as your limited driver's license?
Yes, sir.
All right. And did your green card expire on that date?
Yes, sir.
All right. Your Honor, I would move to admit defendant's exhibit 4.
My objection to is going to be the same as to Exhibit 3, cumulative. I don't think it's relevant. The witnesses testifying, you can take that as how the court deems credible.
Admitted over objection.
Right. Mr. Sani, I'm next going to bring you up what's marked as defendant's number 5. It consists of 3 pages and ask you to identify that. Okay, Mr. Sani, looking at what's been marked B5, consisting of 3 pages, can you tell me what that is?
That is my Norwegian passport, sir, and on page 3 is a stamp that USCIS provided me with, so I have a temporary proof of residence.
All right, so the stamp was put where? In your passport?
Yes, sir.
And I had you get your passport to make copies for me. Did you bring it today in case the state wants to look at it to see its authenticity?
Yes, sir.
And I don't know if the state wants to, Addie, bring it.
Not at this time, Judge.
All right.
This is
All right,
You're satisfied with the copy? And you move to admit that, Mr. Head?
I do, Your Honor, because it's gonna,
And Exhibit 5?
objection, same as 3 and 4.
All right. Admitted over objection.
all right, now, Mr. Sani, when you lived in South Georgia, did you have immigration counsel that you worked with down there?
I did. Yes, sir.
And what, were you working with that immigration firm at the time this case turned up so that you could try to get a new green card?
Yes, sir.
And what's the name of the firm? Just if you don't know it, the best you can remember.
Lloyd Murray and Associates
And what city in South Georgia was he located in?
in Richmond Hill, Georgia.
Okay. And then when you were not able to get your green card renewed, did I send you to a local attorney to see if Charles Cook, K-U-C-K, could help you?
Yes, sir.
Was he able to help you?
Not at the moment because he said I had this issue still pending.
All right.
And he advised me to get this over with. And as soon as I get this issue over with, I could file for citizenship.
All right. So what about the Murray firm? Did they say that something similar to that, or was that any different than they had told you?
They said the same.
Objection, Judge. I'm going to object on hearsay. He's testifying to what someone else told him. And is
Right.
not here to testify.
I'll withdraw the question.
Sustain.
So let me ask you this. Did you pay both of those attorneys to try to help you get a new green card?
Yes, sir.
And were either of them able to help you?
No, sir.
And so were you without a license at this point that we're talking about?
Yes, sir.
All right. And so as far as that situation, can you tell the court whether or not this puts you under a lot of stress in light of all the businesses that you have to get to every day?
Yes, sir. Not only the stress of not having a driver license and way to get to my businesses, I could not also file for like business licenses that were required because they require a valid legal US ID, which I had none.
Okay, make sure you speak up because I'm
Yes, sir.
I can only hear in one ear and it's not working too well today. So you were basically in limbo while you're waiting to get a green card.
Yes, sir.
And so as far as any other part of your life, was there any other than business stress, is there any other part of your life that you were basically embargoed or kept from doing while this was going on and you no longer had a green card?
Basically holding me back from traveling. I can't leave the country without coming back and being asked questions or interrogated about this issue.
Well, let me ask you this. Since this case started, have you made any attempt to leave the United States and try to come back?
I have not. My attorney, Lloyd Murray, told me not to.
Objection, hearsay again.
Sustained.
All right. And so, well, let's put it this way. Had you either read information or learned any information about that might not allow you to come back into the United States?
Yes, sir.
And so, as far as any other situations, were you denied business licenses that you needed to make money during the period that you had no green card?
Yes, sir.
Now, going forward, even though the attorneys told you it was a waste of time,
Objection, that's a question that relies on hearsay.
I'll take that.
Please reframe the question.
I'll
Mr. Head.
rephrase the question.
Sustained.
Mr. Sani, out of in the next several months, when nothing was happening as far as green card, could you tell the court what you did, if anything, to try to break up this problem?
I could only do one thing, which was continuously keep calling USCIS to set up an appointment to give my side of the story so they could understand. And that was the only thing I could do because everything else was out of my hand.
And so, can you tell the court whether or not this status problem and the blocking of being able to get your business licenses, did that cost you money?
It cost me a lot of money. And then also I had like business trips I have to take out of the country, which I can't even make to because I have to go deal with manufacturers of the businesses that I'm in.
So is there anything specific that you know you need to go to, but you cannot and have not been able to?
Like countries?
Yes, what country?
China, Norway to see my family, China for business, India for business.
All right, so what is in China that you need a supplier?
Yes, sir.
And have they invited you to come over there to learn more about their distribution?
Yes, sir.
And have you been able to go?
I have not.
So you mentioned that your mother stays with you when she's here. Where else does she live?
In Norway.
And you have a surviving brother that lives in Norway?
Yes, sir.
And so you said that when she's back in the country, she now lives with you. Is that correct?
Yes, sir.
And did she previously live in South Georgia where you were raised?
She did. I moved her up here 2 years ago.
All right. Is she working anywhere now?
No, sir.
Okay. And does she have her citizenship?
Yes, sir.
All right. And you plan to get your citizenship too, do you not?
Yes, sir.
Okay. And until this case is over, are you able to apply for that and be allowed to be a citizen?
No, sir.
Make sure. And if I haven't already asked that the exhibits be admitted, I would ask the court to admit, I believe it's 1 through 5.
1 through 5 have been admitted.
I think that's it. Your Honor, I think that's all the questions I have for him on this particular subject. And
Did you have another subject you wanted to cover?
I'd rather just focus on this because if this is dispositive, there's no reason to go into the other issues.
All right. Ms. Reiter, your witness for cross.
Thank you. Mr. Sani, you had stated that you have been a business owner for how long?
Since it's been a while now.
I'm sorry, I can't hear you.
2007, 2008.
2007, 2008. Okay. And I think you stated that you had approximately 12 locations that are in Metro Atlanta.
Metro Atlanta and South Georgia, like all over the state of Georgia, basically.
Okay. So 12 different businesses, and are they all different businesses?
They fall, I mean, two different kind of businesses, yes.
Okay. And do you have people that work for you or work with you in your businesses?
I do.
How many employees approximately would you say you have over your businesses?
Oh, close to 50 employees.
I'm sorry, I didn't hear you.
50,
50,
yes.
50. Okay. And prior to this incident on July 29th, 2019, you and your employees were conducting business as normal, correct?
I wasn't at where I'm at today. Back then, I've organically grown through the time.
Okay. And after this incident in 2019, when you were arrested on July 29th, 2019, correct? And is that a yes or a no?
Yes, I apologize.
Oh, you're okay.
Right.
And when you were arrested, you were then released on bond, correct?
Was I still on bond?
No, you were released, like you didn't have to
Yes.
sit in jail
No, I
at
did
all.
not. No, I did not.
So you were released the next day after,
I was
or
released.
within a couple hours, correct?
A couple hours, but next day, yes.
Next day, okay. And so the entire time that since your arrest, you've been out on bond, correct?
I have.
And you've still been working, correct?
Yes, I have.
And you still have been employed and running your companies, correct?
Yes, I have.
And you're still profiting off of your businesses, correct?
Yes, I am.
And you're still managing employees and they're doing work for you as well as doing work yourself, correct?
Yes, I am.
And I know there was some talk about your immigration status. So I want to look back on defendants 5, so a copy of your passport. On that back page, I think it says that you do have permanent residency from this was issued August 16th of 2022, correct?
Yes, madam.
So you're a permanent resident.
Mm-hmm. Yeah, I'm sorry. Yes.
Okay. And this whole time, since this case has been ongoing, you've been a permanent resident, correct?
I have. There was
Okay.
a little lapse of time there for a second, if you look at the dates, because I had to personally keep calling USCIS. My lawyers had told me that, they tried to help me out. They couldn't get nothing going. So luckily, USCIS called me back, or it was an email, and they set up an appointment for where I could go in and finally get this stamp.
Okay, so you were a permanent resident the entire time that this case has been ongoing.
I was.
Okay.
Yes.
And during this time, aside from what you just testified to, having to call the office, you haven't had any other issues with immigration,
I have not.
and you haven't been deported in any way since July 29th to today.
I have not.
So no problems with immigration during the pendency of this case. Now, you said that you have family that lives here.
I do.
And your mom and your brother?
My brother, he stays in Norway. My mother stays here.
Okay.
I mean, she takes her time back and forth.
Okay. Now, I know you had testified on direct examination that since the pendency of this case, you were, I guess, maybe denied a business license for one thing.
Mhm.
Okay, but you were still employed and still making money during that time, correct?
Yes.
And you were still able to work, correct?
Yes.
And you did in fact work.
I did. Yes.
That was a yes.
Yes.
Okay. Your Honor, may I have 1 minute, please?
Human.
And just one other question. So since you were released on bond in this case and during the pendency of this case, how long it's been open, you've still been able to drive a vehicle, correct?
I have.
I'm sorry.
Yes, I have.
You have, okay. No further questions at this time, Your Honor.
All right, on that last question, Mr. Sani, has there been a period of time that you had no driver's license other than that stamp in the back of your passport?
Like I was telling the prosecutor before, there was like a little period of time, I think it was like a week and a half, 2 weeks, when I did not have a driver license. When I was not able to get licenses for my business.
All right, and so can you give the court any specific instances of business deals you've had to turn down due to this case pending, or loss of money from not being able to get a license during the pendency of this this case?
All right, the other business that I'm in real estate. I do multifamily, and I only way I could be, I can't be a direct investor, or I cannot take out any sort of loans because I have any sort of charges pending.
All right, what about licenses for your individual businesses? Have you been delayed or denied licenses because you didn't have the documentation?
For that time period, that week and a half, 2 weeks, I had 2 licenses that were due like a couple months before, but they could never file them because I had no legal ID. Because whenever you're filing for a license online, they only go with a date on the ID. They don't let you give it no further.
All right.
So if it's a year license and your ID cancels in between, they will not give you a license.
All right, so in terms of dollars and money, I know you don't know how much you would have made, but have you had to turn down lucrative business opportunities because you could not participate in this case?
With real estate, yes.
And even in your other businesses, have you had types of licenses that were denied originally because of documentation issues here?
Yes, sir.
And what type of license were you denied?
Tobacco licenses.
A tobacco license for one of your stores?
Mm-hmm. Yes, sir.
And are those individual licenses for every store?
Yes, sir. Each store has their own.
And so are those aren't one license for the whole term. They come up with each different store. It's an annual license.
It's an annual license, and each license starts off at a different date. They are for the same term though. One might start off in January, the other might start off in April, the other might start off in March. So they're all.
Okay, so you've actually been turned down on those licenses.
Yes, sir.
And so and you introduced me actually to one of the business partners at one time, correct?
Yes, sir.
Okay. And he's real.
Yes, sir.
And he has how many apartments on the ground?
Oh, he has 1,500 units just in Metro Atlanta.
All right. And he wants to go into business, but he needs this cleared up. Is that correct?
Yes, sir.
Okay. All right. Has this created any personal stress within your life and in your relationships while this all has been going on?
Yeah, it's caused a lot of stress, like family stress, business stress, stress from my peers, basically because, yes, I understand that one time in my, that time I messed up, but it's like haunting me till now. I can't progress with my life. This has been like 4 years ago now, and I cannot progress with my life with this just looming over me. It's like a guillotine over my head.
All right, has it affected any other personal relationships in recent times?
I was almost married, and my fiance and I have split up now. Reason why, main thing, we can't take no trips nowhere. We haven't been nowhere. We've been together for 3.5 years, or we're together for 3.5 years now. And she just gave up because when is this going to come to an end? You know, she's got a future as well. She has to travel for work, and she might want to like move somewhere, and I can't do nothing with her.
All right, I think that's all the questions I have for him, Your Honor.
Your Honor, I have a couple recross.
You may.
Thank you. Okay, so Mr. Sani, you said that you just testified under examination that it was only a 1 to 2 week period that where you didn't have a license and 1 or 2 business license got denied, correct? So it was just 1 to 2 weeks.
That was like 1.5, 2 weeks. Yes.
Okay. And I think you also testified, let's let me back up. So that 1 to 2 weeks, I understand that maybe a license got denied. But during the time, during the pendency of this case, have you had other licenses that have gone through?
I have, because my everything was, the dates were right, you know. So any license that was like after the date, they did get affected.
But just that 2 week window you
Yes.
just testified to. Okay, so let's take away that 2 week window.
No, but okay. So I see where you're going with this.
No, I'm just asking a question. During the pendency of this case,
I got the
Have
correct
you-
answer for you on that.
have you been able to still get licensed because you seem
That's
to
a
have
good-
everything?
That's what I was
in
about to
mind?
tell you right now. So, all right, say for instance, I had a license that was supposed to expire on, I think my green card expired in August. So say I had a license that expired in June and I had to get it renewed for August. They would not even renew it in June because they don't make a license just for a short period of time. It's either for a year or not. So actually, yes, legally, my thing was out for like a week and a half, 2 weeks, but all my licenses weren't going through because the licenses have to be 1 year at least. They don't make no 8-month licenses, 7-month licenses, 6-month licenses. So if you're not getting a year license, they're not letting them go through.
Okay, I understand that, but were you able during the pendency to still conduct business and get certain licenses?
Yes, with assistance of some of my other business partners.
So exactly, assistance by your business partners. Okay, so you have business partners that can assist you in doing those things, correct?
But I'm the main guy, so everything is in my name. But if I do have to, you know, do something, they probably could assist to a certain extent
So they can assist you in the operation of your business, correct?
in the operation, but not in getting licenses and everything because everything is in my name.
Okay. But you did just testify that they would be able to assist you in whatever you needed for your business, correct?
Like the day-to-day routines.
Okay. And I think you indicated that you, I guess for a short period of time, you couldn't be a direct investor in maybe a piece of real estate, correct?
Exactly, yes.
But didn't you also have other people who could do that on your behalf during the pendency at this time?
I could do it on their behalf, but I'm not making the type of money I should be making because it's my money that I'm using or they're using to make this investment. And now I have to use somebody else's name. And then they want their piece for management fees and all kind of other fees. It's senseless.
So that's a yes to my question, that other people could do it on your behalf?
I mean, all right, I would say no, they could not do it on my behalf.
Well, you just testified.
No, I mean, yes, they could do it
They could do
like
it.
assisting me, but it's my money at the end of the day, so they couldn't do it without me.
So during the pendency, you're still making money throughout your businesses. You're still employed, you're still able to work, correct?
Yes,
You're just claiming now that it's not the amount of money that you want, correct?
yes,
Even though people can still do business on your behalf, correct?
to a certain extent.
And I know you had said that at one point, maybe you were denied a tobacco license.
Mhm.
How were you notified about that? Was it,
From my accountant and, Georgia Department of Revenue.
okay, and do you have a copy of that here today?
I do not.
You do not? Okay. So we don't have that proof today. In terms of sorry, 1 second, Your Honor. And, your other employees, I know you testified that they could do business on your behalf. Would you say they could also travel on your behalf for certain things?
No,
Okay. Aside from not being able, well, you have a permanent resident card now, so you could still travel, correct?
not with pending cases.
Okay.
That's what my attorneys have advised.
Oh, so that's just an advice on the attorneys you have from previous attorneys. That's not from, anyone with the U.S. government, Department of Immigration or anything like that?
Well, these are, immigration attorneys.
No, I know they're attorneys, but I'm saying the U.S. government has never told you that you couldn't travel just because of pending charges.
No, they haven't.
No further questions.
All right, Mr. Sani, just following up on that, in terms of dollar amounts, are we talking about you lost $500 or you lost 500,000 or $1 million? Is it big numbers you've lost?
Like multi-million dollars,
Multi-million.
over
Okay.
$5 million.
And it's not just a tobacco license, it was delayed.
This is with the real estate thing.
Real estate. And so, in terms of traveling, do you know of any place that Google will tell you whether you can get back in the country if you try to leave the country and then come back?
I mean, one place definitely is Canada. They don't let you go there with no DUI cases pending.
Okay. And so, but again, did you on attorney advice, not mine, but on attorney advice, did you not travel by virtue of what you were told by attorneys? No, I don't want to know the details.
Yes.
Right. And so, and as far as the, business opportunities that you've turned down, you were asked the question, if you put millions of your dollars in somebody else's name to try to get the deal to go through, that wasn't something you're willing to do.
No, I am not.
Okay. Well, that's good. That's good. Right. And so, as far as the stress, could you put a dollar amount on the stress that you've had in this last three years, 9 months, 10 months?
I'm gonna be honest with you. I don't even think I can put a dollar amount on the stress this has caused to me.
All right. And you said something about, I never met your fiance, but you said she travels already? She travels.
She travels.
Where's she from?
Cambodia.
Okay. So she was traveling and wanted you to go with her
Back
and
and
you
forth.
couldn't go.
I could never go out. I hadn't taken the first trip.
Okay. I don't think I have any more questions, Your Honor. Thank you.
All right.
And
May I excuse the witness?
I just had a couple follow-up in terms of travel, just.
All right, last recross.
Yes,
Go ahead.
that's right, Charles. So you were the one to choose not to travel, correct?
My attorneys have told me not to travel.
Okay, but it was your decision not to travel, correct?
After they told me that I might not be let back in the country and lose everything I had.
But that was,
Yes.
and nothing was from the US government saying you couldn't travel, correct?
No, it was not from the US government.
And you said, I think you testified that you were trying to go to China at some point.
Yes, ma'am.
And that was during COVID-19.
No,
there-
it was not. It was after. In the last 4 or 5 months.
Okay. No further questions, Judge.
All right, thank you, sir. You may step down.
Thank you, Judge.
Anything else from the defense?
Not in terms of witnesses, Your Honor. I don't know. Don't think you have the cases yet.
You cited Doggett, Wingo.
All right, well, let me put those into the record.
I am trying to, yeah, go ahead, please.
Okay, the one case that is probably the closest in facts is a case called State versus Bazemore, Bazemore, 249 Georgia Appeals 584. That's a case out of DeKalb County in which
What year was it decided?
2001. And it was a misdemeanor DUI in front of Judge Majette. And in that case, Judge Majette granted the dismissal based on lack of a speedy trial, that it was a 21-month total length of time. And the only harm is that his girlfriend left him and that he was completely stressed out by virtue of the fact that he couldn't get the case over with, but she left him and she was a potential witness. That was the only harm in that case. And that was upheld by the Court of Appeals. The state appealed that case. That was all the harm that was required. And if you read the other cases that dealt with misdemeanor offenses, the case always says, can the defendant show harm? You will not find any case of all of them, and I've cited a bunch of them, not one who had the harm that's happened here financially, personal relationships, stress, not being allowed to, or at least being advised by his attorneys to not go out of the country and not be able to get back, because that vacation could have cost him everything. If he couldn't come back and manage his businesses, you can't take that risk if your attorneys tell you not to. But the Taki case, which is, it's spelled T-A-K-Y-I, State versus Taki, that case came, I believe, make sure I've got it right. I don't know. Dixon, Judge Dixon, here in this court.
Okay.
The case started in the city of Atlanta. This constitutional speedy trial, not statutory, was filed there. It was bound over, and in that case, Judge Dixon heard the case and she granted the dismissal based upon the basically the stress that most people went under. And again, there's nothing in these cases that are going to have anything like the maybe it might be a fact witness or somebody that's missing. That case went up twice on appeal, and both times the Court of Appeals upheld it. I think one time they wanted the record to be cleared up, sent it back to Judge Dixon, and she ruled the same way again. So that case is another misdemeanor case. And the Doggett case, and by the way, the Taki case is 322 Georgia Appeal.
I've got it, sir.
Okay. And then the Doggett case is 505 U.S. 647, 1992 U.S. Supreme Court. And it also cites the older case, which is, got it on it, Barker versus Wingo, B-A-R-K-E-R versus Wingo, W-I-N-G-O. And that case is, of course, cited in the 1992 case of Doggett. But that's what set up these factors. And we also have other cases that we have provided to the court, because those cases help give a legal framework. And many of those were felonies, very serious felonies. But in the misdemeanor cases, 12 months is the presumptive time period to get a case. We can't really use the straight 12 months, but well after 12 months, this case was still not even accused. In fact, until you did your April 6th arraignment, he had never been arraigned. And it's not your fault. But the whole point of it is, his life is not only on hold, his life was being bulldozed by financial issues that he couldn't do anything about. None of his attorneys could help him. And so I don't know that there's ever been a reported case that had more harm than this one in terms of how this has affected his life. And so I have other cases, but I think all the ones that were relevant were forwarded to you. So I'm not going to belabor that point, but I do want to make sure all those exhibits are admitted because I needed that paper trail to show the court how this all happened.
Thank you. Ms. Rice?
Thank you, Judge. I'm going to kind of go through the state's analysis on this constitutional speedy. So as Mr. Head had cited, the guiding cases here are Barker v. Wingo, Dodge v. United States, right? So step one, we have to get across the threshold inquiry. So the first step in considering is whether the delay indicates presumptive prejudice, right? So in considering a defendant's claim that he was denied his constitutional speedy right, the trial court is required to decide as a threshold matter whether the delay at issue was long enough to create presumptive prejudice. Mr. Head is correct under, I believe it's pronounced Labie v. State 362, Georgia Act 558, which is a 2022 case. A one-year delay is typically presumed to be prejudicial. The state would concede the defense has met, the case has met that threshold. The rest was, which we calculate the time from, July 29th, 2019. We're here today, June 2nd, 2023. So we've reached that presumptive threshold. Once we meet that presumptive threshold, then we go and analyze the 4 factors set out by Barker v. Wingo and Dodge it. I'm going to briefly go through the state's argument as to each factor. The first factor, Your Honor, is the length of the delay. How long has the delay been? There is no bright line rule that delays must be weighed heavily against the state. That comes from Taylor v. State 338, Georgia Act 804, 2016 case. Judge, the calculation of the time, so if we look, which is what we're the time frame here, is July 29th, 2019 until today. There's 57 months. That's the delay of the total time. However, there's case law out there, Durham v. the State.
Are you calculating from the date of the incident? Or
Yes,
the date of the
so the
okay.
date of the incident, July 29th, 2019 until today, it's about 57 months. Now, what time is attributed to the state and what time can be attributed to the defense, I'll get to in the reasons for the delay, but the total time is approximately 57 months from the date of the arrest to this hearing. I'm asking the court not to weigh that heavily against the state, and I will indicate why in a second, Judge. But there are cases out there, Durham v. the State 355, Georgia Act 426. It's a 2020 case, and the Court of Appeals found that there is no violation of the defendant's constitutional speedy right where there was a 6-year delay. Again, in Holland v. State 357, Georgia Act 87, which is a 2020 case, the court did not weigh a delay of 4 years heavily against the state. Here, Judge, we're at 57 months. Now, the most, I think, important factor in determining, the times or delay and who that the time would be burdened on is the reasons for the delay, which is step 2 in the Barker v. Wingo factors. The state's contention is that the reasons for the delay are not wholly attributable to the state. The defendant was arrested on July 29th, 2019. The procedural history of this case is important, and I know we put that on the record prior to starting the testimonial hearing of this matter. So the case was in Sandy Springs Municipal Court from July 29th, 2019 until February 12th of 2020. That's approximately 8 months the case was lingering in the municipal court of Sandy Springs. Defense counsel and what has been admitted as statements 2 is the Sandy Court Springs records showing defense counsel did not assert a right to a jury trial or a constitutional jury trial demand until February 11th of 2020. Thereafter, when he made that demand, about 7 to 8 months after his arrest, and the case is lingering there, he makes that demand. And then the very next day, the case gets bound over to the state court of Fulton County. Our office, the Solicitor General's office of Fulton County, receives it from Sandy Springs Municipal Court on February 21st, 2020. So I'm asking the court, while that case was the defendant's case was in municipal court for that 7 or that 8-month delay, to not weigh that against the state, because it was in municipal court and his jury trial demand was not filed until it was bound over. In addition, Judge, the case was received in our office February 12th of 2020. February 21st, 2020. Just a week or two later, the tolling orders from the Georgia Supreme Court tolling the statute of limitations, tolling jury trials hit on March 14th of 2020. That order extended for 1 year, 3 months, 16 days. That is just short of 16 months. And I'm asking during that time, during the tolling of jury trials and suspension on jury trials, that delay is not to be weighed against any party, neither the state nor the defense. And that comes from the LeBee case, 362, Georgia App at 560, and also State v. Adams, 364, Georgia App, and that is a 2022 case that was actually went up on appeal in our office on a constitutional speedy. And the Court of Appeals says the time frame of that Georgia Supreme Court order, the 1 year, 3 months, 16 days, should not be held against any party. In addition, Judge, we've had, the case, even during COVID, the case was formally accused November 20th of 2020. He was on a plea and arraignment, which got reset due to COVID on June 22nd, 2021. And then also had a plea and arraignment on August 25th, 2021, where he waived and asked for a jury trial. Another important factor, Judge, is, and I know the court is aware, I would ask to take judicial notice of the backlog of cases due to COVID and the creation of the Orca trial division where this case is currently pending. This case was transferred to the Orca division on March 2nd, 2022 from Judge Richardson's courtroom. The court, is aware that this division was created to assist and tackle the backlog of cases due to COVID. And the 10 state court judges in Fulton County were able to transfer some of their backlog cases that had incident dates between 2015 and 2021 to this Orca division to help with the backlog. And that is what happened in this case, Your Honor. And so if you're looking at the calculation of time of how long this case has been arguably pending, I'm asking the court to exclude the time, the 8 months it was in municipal court, excluding the 1 year, 3 months, 16 days of the tolling order and suspension on jury trials. That leaves approximately 24 months. During that 24 months, there have been court dates. There have been court dates and motions filed by the defense. And I'm asking that that 24-month delay not be held heavily against the state due to there's no evidence that it was an intentional, deliberate delay by the state, nor is there any bad faith on behalf of the state that caused the delay. This 24-month delay arguably can be attributed to the backlog of cases created by COVID-19 and the suspension of jury trials. And that brings us to factor 3 of the Barker-Wingo analysis, the defendant's assertion of a right to a speedy trial. Although the state does bear the burden to ensure that an accused is brought to trial promptly, the defense still does bear some burden to invoke the right to a speedy trial. And that comes from State v. Buckner, 292, Georgia at 396. And like I had previously stated, Judge, this case was in municipal court for 8 months, 8 months. And it wasn't until month 8 that the defendant wanted the case bound over to municipal court. So I'm asking you to weigh that 8 months heavily against the defendant. He could have resolved his case in municipal court. I understand he has a right to a jury trial, but if this case, if he wanted it to be resolved quickly, it could have been resolved in municipal court. Instead, he had the option, and then he chose to exercise his right and bind it over. So that 8-month delay should be held heavily against the defendant. He could have immediately requested a jury trial if that's what he wanted, instead of waiting 8 months in municipal court. He could have went to his first court date in municipal court and requested a jury trial. And he also, the defense, when the case was in state court, the defense counsel filed a motion for discharge and acquittal based on the constitutional speedy on September 7th of 2021. The case was received in our office and accused in November of 2022. That's also another approximately, close to a year where defense didn't seek a ruling or seek a jury trial demand. He could have, the motion was filed, he could have asked the court or asked Judge Richardson or asked somebody for a ruling on his motion, and that didn't happen. And that brings us to part 4 of the analysis. Prejudice to the defendant. Judge, that is a 3-part test. The first part is preventing oppressive pretrial incarceration. And these are balancing factors, Judge, that the court will need to weigh. But preventing oppressive pretrial incarceration, defendant has been out on bond this entire time. He has not been oppressed in any way in terms of incarceration since his arrest date, which he was released the very next day. B, minimizing the anxiety and concern of the defendant. I know we heard brief testimony from the defense that he did experience some anxiety and concern, not any more than what a normal defendant in a criminal case would go through. And I would point out that these are misdemeanor charges. The max is 12 months, right? There are cases and I can cite to them, cases where people are charged with felonies, incarcerated all the way up until their trial and facing, life in prison. And the court found in those cases that the anxiety that the defendant had testified to is no more than that of a regular defendant. And that police judge is Davis East State, 308 Georgia at 843. And that is a 2011 case. And then I'll also rely on Marshall v. the State, 286 Georgia 446. And we finally get to the last portion of the prejudice analysis is the other factor, limiting the possibility that the defense is impaired to determine if the defendant was prejudiced. There has been no evidence today that the defense of this case has been impaired. Nothing. Rather, all of the evidence is still here, ready to go. We have copies of the police report, the videos, the blood test, the officer, which part the state has talked to recently. They're all here, ready to go. There has been nothing lost, nothing not preserved to my knowledge. I'm sure Mr. Head will correct me if I'm wrong, but the defense has not been impaired to the fact that it would prejudice him. And that's an extremely important point because there are cases, Judge, in addition to the Marshall case and the Davis case, where the Court of Appeals was analyzing this factor under prong 4, prejudice to the defendant. And there are cases, the Marshall case, I believe, where the defendant was incarcerated during the time, and 2 of the defense witnesses passed away due to the delay. The Court of Appeals even held in that felony prosecution that did not prejudice the defendant in any way. And I think that speaks volumes here, Your Honor, because when you look at the fact that the defense is impaired, we have no evidence of that here. All the evidence is here, ready to go, ready to resolve the case. And you heard a lot from the defendant about his, maybe some problems or some issues within his employment. But if you heard on cross-examination when I was asking him questions, during this entire time, he was still working. He was still able to drive, except for that 1 to 2 week window. He was still working, employed, running businesses, running companies. He said 12 locations that were managed by him. He's not been impaired to the fact that it would create such a prejudice against him. He testified he's still making money, maybe not the money that he wants to make, but he's still making money. It's not that we're sitting here in this case is preventing him from doing anything in his life. You heard testimony from him that there's other people in his business that can do things and have done things on his behalf. And also during this time of this pendency of this case, he's still able to get certain licenses. You know, there's an allegation that there was a tobacco license that he wasn't able to get. We don't have proof of that. I know he testified to it, but we don't have that valid proof. There's a claim that he couldn't travel, yet when I asked him on cross-examination, it was his choice not to travel. He had nothing from the U.S. government or, agents with the, feds saying you can't travel. You won't be released back into this country. In fact, he was tendered in as defense 5. He's still maintaining his permanent resident status as the court has seen. So Judge, I'm asking at this point to deny the motion for discharge and acquittal based on a constitutional speedy. One, because the delay, which is that if the calculation is, my calculation is correct, 24 months time that they're looking at, shouldn't be weighed heavily against the state for the reasons I set forth and given the procedural history and the backlog and COVID. But also, I think I assert that there's a lack of evidence presented today to show prejudice to the defendant enough to discharge and dismiss the entire case. Given the fact that his defense of this case has not been impaired. Yes, he may have experienced some bumps in the road, but not significant enough to, as the defense is claiming, ruin his life or subject him to unruly. He can't work, he can't do anything. But we heard just the opposite when cross-examination. He has been working, he has been driving, he's making money, he has the ability to do all of that. He's still a permanent resident, still has all of that. Nothing has affected his defense going forward. So I'm asking you to deny the defendant's motion, Judge.
Thank you. Mr. Head, I'll allow for a brief rebuttal,
All right, Your Honor.
not too long.
It won't be very long. I'm gonna make sure I talk to the microphone. A lot of felony cases were cited in there. Felony cases aren't what we're talking about. But the Taki case, that was an immigration case. That case was not even close to this number of months. And in the opinion itself, it says this is right in the opinion. In evaluating the final Barker Doggett factor, courts must consider 3 types of prejudice, and she just talked about that. Anxiety and concern of the accused and the possibility that the accused defense will be impaired. It's just a possibility. It doesn't mean it will. But in this particular case, the court said, regarding anxiety and concern, the trial court found Taki suffered unusual and extreme anxiety and emotional pain due to her uncertain immigration status, such that she was frightened that at any time her unresolved immigration case could force her to leave the United States. Different situation. But in his case, we're talking millions of dollars. He couldn't do deals because of this. As far as whether or not the case moved any further, what the prosecutor doesn't know that Sandy Springs lost their prosecutor. We didn't have a prosecutor for 7 months. And then Steve Ellis came over from Cobb County. And when I first met him for the first time, he said, no deal, I bound it over. She doesn't understand that the court was dysfunctional when the prosecutor up and quit and left them with no prosecutor. I went to court, there was no prosecutor. And that's the reason I put the record in. I put the record in showing I went to court, but there was nobody there to talk to. And so as soon as we found out we weren't going to be able to work something out, I bound the case over the very first time I saw a prosecutor, very first time, Steve Ellis. And so I don't know how you ever gonna find a case with more prejudice than this. All that happened in Lockheed is that she was worried she was gonna get deported. That's all it was. That's it. He hasn't been able to travel. He has a fiance from another country. They never got to be able to travel. 3 years they were together. They're not anymore. I don't know how you can have more harm than this. I really don't know how you can have more harm. And in fact, one reason I went to get that record is because you wouldn't know what happened, but if you look there, we never had any prosecutor in that court. When she quit, she was under contract. She just quit one day and went back to Cherokee County where she lived. And it was very frustrating. When you're in that court, you don't want to just bind something over till you talk to a prosecutor. But Steve Ellis, as soon as he saw the case, he said, "I can't help you." I said, "Thank you." And the very day I went to court, I bound it up first time. So I just need to see how the court cannot rule. If you read all these cases that are misdemeanors, this is not a felony case. This isn't about incarceration. This is about damage to relationships, damage to financial. And my son-in-law is from Ukraine. I understand this stuff. So.
Thank you, Mr. Head.
Judge, I just need to put something on the record, please. I will be brief.
All right.
Because counsel's referring to the Taki case. So I want to point into that Taki decision. It reads, the trial court in determining the prejudice or the harm that was suffered from the defendant about her immigration. It said the trial court heard testimony from Taki and her attorneys about the actions they took regarding her pending citizenship application and the emotional impact the attorneys understood the situation to have on Taki. We don't have that evidence. We don't have the evidence that the defense is saying other than the defendant's testimony. It stressed me out and they wouldn't let me back in the country. That's completely speculative. Speculation. When I asked the defendant on cross-examination, did that come from a government agent of the United States that would prevent you from doing that? He said no. So we don't have the evidence of the immigration issues that is being claimed. Rather, we have from Defense 5 that he is a permanent resident. We have that. He does not have any immigration issues if he's a permanent resident, Your Honor. And in regards to Mr. Head talking about the felony cases that I cited, I understand they're felony cases, but they are relevant because the analysis is the same on a constitutional speedy. Regardless of the charge, whether it's felony or misdemeanor, the analysis on the harm prejudicial factor is the same regardless of the case. So I'm asking the court once again to deny the defendant's motion. Thank you.
The motion is denied. Even though the defendant had a significant delay, we are under extraordinary circumstances. We have the backdrop of the COVID. We have the backdrop of the suspension of court businesses that has caused an extraordinary delay in thousands of cases being addressed. The creation of the Orca was created by the courts with the assistance of both the state and the defense to try to address the backlog of cases. I do find that there was an uncommonly long delay in this particular matter, but I do not attribute the blame of this delay to the state, nor do I attribute the blame to the defense. It's more in the context of the environmental situation that we're in, the fact that court could not address the cases as they should have. And unfortunately, a very, very tremendous backlog was created, and everyone within the organization of the court structure, the state and the defenses have been trying to address these backlogs. In terms of prejudice, I agree with the state, even though there was stress placed upon the defendant with regards to travel, with regards to the speculative issue of whether he would be let back into the country, I do understand that this is on the advice of immigration attorneys. However, there was no specific evidence presented that he is not allowed to travel. To the contrary, we have evidence that he was a valid permanent resident and he was not in what we call a removal proceeding. He was not in an undocumented status that prevented him from traveling. I do recall the defendant's testimony that if I do travel, it might be subject to interrogation or questioning by customs. I do not find that to be an undue prejudice to the defendant if he chose to travel against his immigration attorney's advice. There is no evidence or other than a blanket assertion that he has lost millions. There is no evidence other than a blanket assertion that he was stressed. I do not know why he and his fiancée broke up. Perhaps it was their inability to travel. But then again, I go back to the same argument with regards that he did not have a ban on travel. He chose not to travel because of the discomfort of being interrogated by customs with regards to open cases. Now, the fact that he could not travel to Canada, I have no evidence that this has impinged on his or caused any prejudice to him. With regards to family contact, yes, he may not be able to travel to Norway to visit his brother, but the evidence clearly shows that family could travel to the United States to visit him or stay with him. So I do not find any prejudice to that effect. Again, in the context of the backdrop that we've experienced in the last few years, with regards to the COVID, the shutdowns, the emergency orders, the protocols with regards to how we had to handle with the backlog of cases, everyone on this planet have gone through a level of stress, a level of anxiety, and unfortunately for Mr. Sani, I don't find his situation to be extraordinarily different to the point that it requires me to have found that his speedy trial demand has been violated. The motion is denied. The state can present an order with regards to that. That leads us to your next motion, Mr. Head.
Your Honor, I cited the cases that were relevant in there. And I'll let
Are we talking, yes, all the cases you cited, I've had ample time to review them as well while you were looking for the exhibit stickers. So I'm very comfortable with my decision. Thank you very much. Someone has are you with Mr. Head's office?
I brought him exhibit stickers.
All right, well, may add to the
I
roll.
went up to another judge's room. And I told them I was going up and one of the other judges in Superior Court judge.
Well, mine are white. Sorry for.
Okay. All right, well, thank you.
All right. Okay, I have the motion for discharge and acquittal.
That was the constitutional speedy judge.
Yeah, that's been denied. That gives us next to the motion to suppress, followed by Mr. Head is also in the alternative and motion in limine with regards to I believe when I was reading through the case file that Mr. Sani had allegedly agreed to take the blood test pursuant to the request under the implied consent notice that was read to him. I'm just going on just the allegations. All right, Mr. Head. So is that the motion?
The motion is the fact that in this case that he was asked to do an invasive test when there was no evidence of any type of anything.
Before we address the motion, shall we, if y'all can object to this, I'm just asking, for just the purposes of this motion in limine, I want it to either be stipulated or agreed to that the implied consent notice for drivers age 21 and over was read to Mr. Sani, that Mr. Sani agreed that the officer requested a blood test and that Mr. Sani agreed to take the blood test.
Your Honor, I think if in light of the fact that we're going to go on that, the court needs a copy of the,
I'm looking at your motion.
a copy of the video. since you don't know what happened in the case.
Well, no, I'm not seeing the video. That's absolutely right. I'm just going by the incident report
Well, I'd like to make that exhibit.
and the
6.
warrant. Yeah, sorry?
I'd like to make the video we received from the state as exhibit, I think it's 6 or 7. I'm not sure which.
Judge, I'm just confused because the motion that was filed is not challenging anything about the implied consent that was read, his consent, or anything about the blood draw. What the defense has challenged in this motion is the implied, I'm going to read from the motion. The flawed implied consent statute violates the defendant's rights to due process under the Constitution because the officer did not offer the defendant either a breath test and or a blood test. I believe Mr. Head's argument is that the implied consent statute is flawed because it allows the officer to designate what test. And his allegation is that the officer chose blood, and that's a more intrusive option than breath.
Mr. Head, how would me seeing the video add to the arguments that are currently set forth in your motion?
Because the officer tells him he thinks he's under the influence of alcohol. And alcohol has a breath test that's perfectly legal to use. The only difference between the Elliott case and now is that you couldn't use, if the person did refuse, you couldn't use their refusal for a breath test as evidence in the criminal case. You still can, it's still an admissible test. But the officer says nothing about suspecting anything except alcohol. He says you're drunk. He talks that way. So of course, I didn't care if they had the officer show up, but if the video, if the court doesn't have the video, then that needs to be watched before you make a decision on this one.
All due respect, Mr. Head, the request to show the video is denied. Are we ready to argue the motion?
I'll just let my brief, the cases I cited in there.
And
Yes.
if I can just put a brief on the argument side for the state judge. If you look in the defendant's motion in terms of challenging the flaws, Mr. Head is challenging that the implied consent statute is flawed because it allows the officer the discretion to ask for any test. One, it's not an unfettered implied consent. The implied consent statute is not unfeathered or unthing. It is based on the officer has to have probable cause in the arrest. The defendant has then read the proper implied consent, and then he consented to the test. Case law and the statute, OCGA 40-5-67.1A reads, subject to code section 4-6-392, the requesting law enforcement officer shall designate which test or test shall be administered initially and may subsequently require a test or test of any substances not initially tested. And again, that's supported in case law, Jordan v. State 223, Georgia App 176. The current law in Georgia is that once there's an arrest based on probable cause, the officer can read implied consent, and it's his choice to determine which test is given. That's what the law is. There's no other case law cited that says anything other than the defense. And what's important, the Olivet case already held that the implied consent statute is not coercive and is not unconstitutionally misleading. This case law has already been set in place and is very clear on the status of the Georgia law. The officer had every right to ask for a blood test.
Anything else, Mr. Head?
The case you cited, the Olivet case, was decided under the old implied consent warning that has been thrown out.
To some degree.
Excuse me, Your Honor, I just need Mr. Head to speak a little closer to the mic. Just
Yes,
thank you.
I'm sorry. Thank you. That case was decided before Elliott.
Mhm.
And it had the old warning, which Elliott said was incorrect in the Elliott case. But what I'm arguing is US Supreme Court cases the McNeely case.
And the Birchfield case? Mhm.
Those cases have set the precedent for what this motion is. And yes, the implied consent warning is defective. And the reason it's defective is because without the necessity of a warrant or without getting a warrant to simply ask for an invasive type of test when you suspect nothing but alcohol, that is a too invasive test. And there's nothing in this evidence in the case, and the officer wrote down in his report, everything is all under the influence of alcohol. Wasn't anything else. But the fact that he asked for blood without going to a judge for judicial warrant, I think the McNeely case and Birchfield case stand for that proposition. If he had refused blood, I don't think he would have had any issue for doing this, but because once he was read the card, and this was the current card, it wasn't the old one like Oliver, he was told he would lose the right to drive for 12 months.
Mr. Head, in the Birchfield case, wasn't that the situation and it was North Dakota, right? Wasn't there a situation under their law that if you refuse the blood test as read under implied consent, that you're actually charged with a misdemeanor offense?
There were 3 different cases in Birchfield, 3 different jurisdictions.
All right.
And Judge, the state would contend a reading of Birchfield stands for that exact proposition. Birchfield is, what the premise of Birchfield is that the state cannot make it a separate crime to refuse to consent to a blood test. Here, we're not making it a separate crime. He consented.
I understand. Thank you. Thank you,
Yes.
Ms. Weiser. So back to my question, Mr. Head. The issue of the invasiveness of a blood test was due also under those specific facts in Birchfield. We don't have that situation here. And that the refusal to take the blood test resulting in a loss of driving privileges, are you saying that is also some measure of invasiveness?
To use a blood test, it is when the only thing you suspect is alcohol. You didn't ask for breath first. If you asked for breath first and the person said no, then you could reread it for blood. And if you didn't get blood, you have the right to go to a judge to get a warrant.
Okay.
And you can get an electronic warrant these days in 30 minutes.
Mr. Head, I've read through the motion. I've actually gone through the cases that you've cited in there before I came here this morning. So, and all I'm going to say right now is that is a legislative issue. The implied consent notice under 4567.1 did go through a redrafting, and it has passed muster under our Georgia courts. The fact that it's not consistent to the degree what you want it to be with either the Birchfield case or the McNeely case as issued by the US Supreme Court does not render our current implied consent notice law invalid, nor does it mitigate or require the police officer to consider, to invalidate the police officer's option and discretion to choose what kind of bodily fluid or breath they would want to choose for the defendant when they read the implied consent notice. That was a very wordy way of saying that the police officer still has the right to choose. The motion in limine is denied.
And Your Honor, once the order is drawn up, could I get to see that before the court signs it, or is it just going to come to you?
It's just going to come to me.
Okay.
All right. This case is scheduled for a jury trial on June 27. I presume both sides are ready to move forward.
Well, and this is that's what I was trying to get to. Once the order is filed, many of the cases that I've cited to you follow this path, which went up on interlocutory appeal. I would like to have these issues decided, because then we wouldn't have to take up any jury trial. And this case, if it comes back on appeal against us, then we're in a whole different process versus this case going to trial on the 27th and then possibly doing a post-trial appeal.
Okay.
I see no reason to waste that time if I do an interlocutory, but I have to get it to you within 10 days of the filing of the written order, and then we can ask for it. What happens in interlocutory is if they don't want to take it, we'll know in 30 days.
All right.
I would object. I don't think it's necessary for an interlocutory appeal. I think the court's analysis is very thorough. Court of Appeals, I believe, is on abuse of discretion. I don't think it's necessary to delay it for appeal. Like Mr. Head said, if his client's convicted, he can appeal that post-trial. I just don't think it's necessary, Judge, and I would object to it.
Well, let's look at it this way. Court of Appeals doesn't have the same backlog you do. Your courts have a backlog. No reason to do any type of trial if we could change our position. If you're wrong, you understand the whole case goes away on the first issue. So I see no skin off the court's nose because y'all have enough cases to try plenty of people asking for it. So I think the ruling is incorrect. Respectfully, I think it's incorrect. And if we're wrong, then, you know, that time he and I will meet and we'll sit back down and talk to the prosecutor. But I see no reason for us to take up any jury trial time when a case has clear issues that this is going to make or break the case.
The request for interlocutory appeal is denied. And even if one was submitted within 10 days, I would deny it. This case is going to trial on June 27th.
All right, thank you.
All right. Ms. Greenhouse, that concludes the hearing. Thank you so much. I don't know
Excuse
which
me, Judge Law, may I just ask Mr. Head if he would be so kind as to send to my email address a copy of the 5 exhibits? And I'll be glad to give him my email address.
Do we have your email address? It's already been admitted and the court will send it to you. Is that all right, Mr. Head?
I want the court to touch it. I don't want to be involved.
All right.
Okay, I do have a Fulton County email address and I also have a personal email address. So,
If you want to put in the chat to Monica Redden.
okay, I'll do that. Thank you so much.
Monica, is that your? Yeah. And she will make sure that the 5 exhibits are sent to you. I just want to make sure that they were on the. Mr. Head, do you have the 5 exhibits? They were they returned after the witness step?
I see that number 3 and 4 are.
Yeah, 1 and 2. 1 was the
Here's 5. Here's
Yeah,
5.
that's it. That's fine. One was the order from Superior Court.
Mhm.
2 was the Sandy Springs certified
Did
document.
you bring them back with you?
Email to you, sir.
I think you put them, I
It
think
was
you.
3, 4, and 5. She's correct. 1 and 2 are the documents. 3, 4, and 5.
They're still up there.
Look, I
This
think,
is 3,
I think
4, and 5.
you email 1 and 2.
I have 1 and 2 in my possession. Hold on.
Yeah, I think I should go over it.
We're just identifying the documents that Ms. Redden is going to be scanning and emailing to you, Ms. Greenhouse. All right, Ms. Redden, you have Ms. Greenhouse's email?
Oh, I have them all.
Okay, found it.
1, 2, 3, 4, and 5.
Thank you. All right. This will be in recess until 1:30 for our status calendar. Thank you.
Thank you, Judge.
Thank you. And Ms. Reiser, if you could get those orders, you can email them to Ms. Redden
Okay.
and CC Mr. Head.
Yes, I will.
And Ms. Redden will make sure that I look at them and then they're filed as soon as you get them to her.
Okay, I'll say the speedy trial one. I'll just need a little bit of time just because I have to. put it in the
Understood. Okay, thank you.
process, But I will send it to you.
And when they're emailed, can I get an email copy?
Yeah, I've just told her to CC you on those.
Thank you. Okay, thanks.
Ken, I thought you were already going to be retiring, standing your toes on the Amelia Island, enjoy
No. I'm not retiring. I just changed jobs.
Change jobs?
I do internet marketing for attorney.
Oh, okay. Oh,
But finish-
Less stressful.
I have 4 or 5 cases still remaining and I don't want to not be available for those.
I totally agree. I really thought that
I think you're talking about George Stein. He has houses all over the place.
No. Mr. Bubba Head, long as I'm starting in law school, it's always been the authority on, we've got one of the best of the best.
I'm sort of like Jerry Lee Lewis. He called him the hardest. I was at work this morning before 4 o'clock, so that lets you know my usual schedule. So.
Oh, wow.
Excuse me, Judge Law,
Yes.
am I excused? I